Good morning, everybody. My name is Kristen Juris, and I'm a professor of property law at the University of Montana School of Law, and it's my pleasure to welcome each of you this morning and to give you an introduction to the case. Although it looks like we're in a university theater, this is, in fact, a court of law. And some of the rules are that we'd like to request everybody to please turn off at this time any cell phones or other electronic devices that beep. It's appropriate in a court of law to remove all of your caps. And when the justices come in and are introduced, it's appropriate for everybody to stand until the justices are seated, and then we can be seated. We also stand at the end of the hearing when they leave. The hearing is going to be approximately 70 minutes, and during the hearing, please everybody keep your seat. If you absolutely have to leave, please try to leave between the first side speaks for 40 minutes and then the second side, so try to leave in that little change of time between speakers. For a number of years, the Montana Supreme Court has tried to help the public understand its role by going out and having public hearings such as this. And I'd like to give you an overview of the legal system. In Montana, we have three legal systems. We have the Montana state legal system, we have the federal system, and we also have tribal courts. You are in front of the Montana State Court this morning. And in Montana, we have district courts, and that's where trials originate. And this particular case arose out of the district court sitting in Missoula County. If one party or the other is unhappy with the results of their trial at the district court, they can ask the Montana Supreme Court, which is an appellate court, to review the decision of the trial court. So today, we are not at a trial, but we are listening to the appeal of a trial from a district court in front of the Montana Supreme Court. The parties who are appealing are called the appellants. So you might hear that word, appellants, and they argue first. The other side is called the appellee, and they will be arguing second. Now, in some states, there's an intermediate court. You go from a trial court to an intermediate court of appeals and then the Supreme Court. But in Montana, we only have one appellate court, and that is our Montana Supreme Court. We also have in Montana federal district courts. And there's a few differences between the federal district courts and the Montana court system. Montana judges are elected. They're elected by the public. Federal judges are appointed. They're appointed by the president with the advice of the Senate. In Montana, we have several federal district judges. There's Chief Judge Richard Siebel, who is in Billings. There's Judge Donald Malloy here in Missoula. And there's Judge Sam Haddon in Great Falls. We also have two senior status judges, Jack Shandstrom and Charles Lovell. We also have in Montana magistrates who work in the federal district system. And in Montana, we have Magistrate Lynch here in Missoula, Magistrate Strong in Great Falls, and Magistrate Osby in Billings. Federal courts primarily hear matters of federal law. For example, whether wolves should be delisted under the Federal Endangered Species Act is a matter that's been heard here in Missoula by our federal district court. They can also hear matters involving state law. For example, if a plaintiff, the person who brings a lawsuit, is from a state other than Montana and is suing somebody, the defendant in Montana, when they come from different states, a federal court in certain circumstances can hear those matters even if they raise state law. The matters that you're going to hear today involve Montana law. So let's talk a little bit about the case today. Matthew Summers and Heidi Ames first brought a lawsuit in the Judicial District Court in Missoula in front of Judge Deshaw. I may have mentioned this, but the person who files a lawsuit is called the plaintiff. So you might hear that word, the plaintiff. And the person against whom they bring a lawsuit is called the defendant. So I'm going to refer to the plaintiffs as Matthew and Heidi. And the person they brought the lawsuit against was Crestview Apartments. And the lawsuit revolved around a lease, a residential lease, which is important for all of you to hear some of the matters that you're going to hear about today, because almost every one of us in our life enter into a lease. And I hope after hearing this encourages each of you to read your leases carefully and to understand exactly what it is that you are agreeing to. The lease in this particular case was one of the Crestview Apartments located out on the expressway in Missoula. Now, a lease is a contract or an agreement between two or more parties. It also, however, has some property law implications. Now, with regard to contracts, Montana and all other states follow the principle that the parties are free to enter into whatever agreements they choose to. We call that the freedom of contract, and it's one of my favorite principles since at times I also teach contract law. On the other hand, courts are worried about contracts where perhaps one party may have more bargaining power than another party. And courts might also want to prohibit some sorts of contracts by statute. They may want to limit your ability, for example, to enter into a gambling contract. So our freedom to contract is not absolute. There are some boundaries around it. In Montana, there was a perception that tenants, those are the people who lease property, a renter, a tenant. Another word you might hear to describe that party is a lessee. They were concerned that tenants don't have the bargaining power that the property owner or the landlord, also called the lessor, might have. So they have enacted some special laws governing residential leases. The Montana Residential Landlord and Tenant Act is going to be discussed at length this morning. There is also the Residential Tenants Security Deposit Act, which governs security deposits. Now, these laws define the duties of both the landlord or lessor and the tenant or lessee. For example, these laws in Montana require the landlord to provide heat and running water. But you know what, in Montana? You only have to provide heat from October to May, so they can turn off your heat in the summer. It also requires the landlords to install smoke detectors, carbon monoxide detectors, and generally to maintain the apartment in a livable or habitable condition. The tenant has duties also. For example, it's your job to flush the toilets and keep the bathroom clean and take out the garbage and keep the inside of the apartment clean. And you can't damage any apartments that you're residing in. You can't be so loud and party so late into the night that you disturb your neighbors. So both tenants and landlords have duties. This act also places some limits on provisions or terms that you can include in a lease. For example, you may be surprised to hear this, but in Montana, it is prohibited to prohibit a tenant from keeping a firearm in the apartment or the dwelling unit as long as the tenant has the right to own a firearm. So a landlord can't impose a rule that says no firearms allowed. And there's other similar prohibitions throughout this statute. Now, when you enter into a lease, how long does the lease last? If the parties don't state otherwise, a lease lasts from month to month. And you can terminate a lease by giving the other side 30 days' notice. However, And not uncommonly, the parties can agree to a longer term than 1 month. And in this particular case, the parties agreed to enter into a lease that lasted for a year, or 12 months, from July 1st, 2006 through June 30th, 2007. And Matthew and Heidi agreed to pay rent of $935 a month. The landlord also asked for a security deposit, and this is an amount that's agreed to between the landlord and the tenant. There's no fixed amount that you can ask for. Often it's 1 or 2 months' worth of rent. But in this particular case, Matthew and Heidi paid a security deposit of over $2,000, $2,170. The purpose of a security deposit is that the landlord at the end of the lease would have a fund to look to if there's unpaid rent, unpaid utility bills, or some damage or cleaning that they have to do. And then generally they're required to return that deposit after deducting any lawful charges to the tenants within 30 days of the end of the lease. For personal reasons, Matthew and Heidi decided, even though they'd entered into a 12-month lease, to leave after 4 months. So they stayed July, August, September, October. They paid their rent through those months, and then they moved out November 1st. So one of the key issues in this case is whether Matthew and Heidi are going to be obligated to pay for the remaining 8 months of the lease. When this issue is discussed, you're going to hear some of these terms. Breach. What is a breach? A breach is when you break your promise or you don't do something that you promised to do under an agreement. If there's a breach of an agreement or contract, often the other party suffers damages. And the landlord in this situation is asserting that it suffered damages because now it has an empty apartment that it had hoped to rent for $935 a month for 8 more months. Another term that you're going to hear is the term liquidated damages. Liquidated damages are damages that the parties agree to in advance as the amount one or the other will pay if there's a breach of the contract. For example, if you agree to sell your used Xbox to your friend for $100 and they give you a $5 down payment, you two can agree that if for some reason your friend breaches and doesn't fulfill her promise to purchase your Xbox, you can keep the $5 as liquidated damages. That's an example of a liquidated damages clause. Another term you're going to hear is acceleration of rent. And what that means is, under the terms of the lease, Matthew and Heidi were to pay rent on the first day of each month. They leave after 4 months, and they have 8 months' rent owing. Normally, they'd pay that November 1st, December 1st, January 1st, etc. But the landlord said, because you breached your agreement and moved out earlier than you promised, I'm going to accelerate that rent, and it's all going to be immediately due and payable. And that's actually a fairly common clause in leases in Montana, especially for reasons of property law that we're not going to get into today. So you're going to hear this acceleration clause discussed, and whether it's lawful in a residential lease to allow the landlord to accelerate the remaining rent due if you terminate your lease early. Both parties, when they discuss this issue of liquidated damages, are probably going to refer to the Arrowhead case, which is one of the Montana Supreme Court's recent decisions where they talk about what laws govern liquidated damages. And that case involved a teacher's contract where a teacher, when he terminated his contract about 3 weeks before school started in August, was required to pay 20% of his salary he otherwise would have received as liquidated damages. Now, Matthew and Heidi are also going to discuss whether Crestview, the landlord, fulfilled its duty to mitigate damages. If you suffer damages under contract law, you have a duty to do what you can to reduce those damages that you'd otherwise suffer. For example, a landlord would have a duty to try to release that empty apartment. And if they do release the empty apartment, maybe it's only empty for 2 months or 3 months, and then they lease it for the remaining months of the term, they don't have damages after they leased it. So you're going to hear discussion of whether Crestview, in fact, did everything that it should have done to mitigate their damages. Another issue that is going to be discussed is whether a landlord can impose collection fees on a tenant. After Matthew and Heidi left, Crestview Apartments turned their account, the remaining 8 months of the lease, over for collection to a collection agency, and then charged a 50% collection fee for collecting. When this issue is discussed, you're probably going to hear terms contract of adhesion. What's a contract of adhesion? A contract of adhesion is generally when a standardized form of agreement is drafted by a party with superior bargaining power, and it's presented to another party whose choice is either take it or leave it. For example, how many of you have done a click-through agreement on your computer software programs? When you click through those agreements, do you think you can say, oh, no, I don't like that provision, I reject it, or do you have to accept it all? That's an example of a contract of adhesion. You're also going to hear the term unconscionable. A court cannot enforce an unconscionable clause, and Webster's dictionary defines unconscionable as unfair, unjust, or unreasonable. The Montana Supreme Court looks at whether there's been oppression between the parties and a disparity of bargaining power that warped the negotiation process between the parties that requires the court to step in and reform the disputed contract term. Another issue in the dispute relates to attorney's fees. When, under Montana law, does one party have to pay the attorney's fees incurred by another party? And this is an important issue because it can quickly add up to thousands of dollars in attorney's fees for Matthew and Heidi or Crestview when they're bringing a lawsuit about the terminated lease to the court. Another issue is the security deposit. After Matthew and Heidi left, the landlord wrote to them, remember they deposited about $2,000 as a security deposit, and they withheld some cleaning fees, $168, and then they informed Matthew and Heidi that they were keeping the remainder of the security deposit to apply towards those 8 months of rent yet to come due. And the question is whether you can withhold from a security deposit future rents that were due under the lease. The last issue that's going to be discussed is whether this lease violates the Montana Consumer Protection Act, which is a law intended to protect the public from unfair or deceptive practices. And Matthew and Heidi will argue, and Crestview will contest, that this lease constituted an unfair and deceptive practice because it contained some clauses that were prohibited by the Montana Landlord and Residential Tenant Act. So we're going to take a few minutes now and get the stage set for the attorneys and the parties to arrive, and you can rustle around until the justices arrive, and then our official court session will begin. Thank you for being here.
All rise and give your attention, the Honorable Justices of the Montana Supreme Court. This court is now in session.
Good morning. I'm Mike McGrath, Chief Justice of the Montana Supreme Court, and I, on behalf of the court, would like to welcome you all. We appreciate the fact that you're here today to listen to this argument. We hope that you'll find it to be interesting, and I'm sure you'll agree that we've done the right thing when we're all done. Let me introduce the other members of the court. On this end of the table, Justice Jim Rice, Justice Brian Morris, Justice Jim Nelson. On the other end of the table, Justice Patricia Cotter, Justice William Liepard, and Justice Mike Wheat. This is cause number DA 090489, Summers versus Crestview Apartments. Counsel ready to proceed?
We are, Your Honor.
Yes, Your Honor. Mr. Saul.
Good morning, Mr. Chief Justice, Justices, Professor Juris, Mr. Hess-Homeyer, and ladies and gentlemen. May it please the Court, my name is Michael Saul of the law firm of Saul & Wolf here in Missoula, Montana. I represent the plaintiff and the appellants in this matter, Matthew Summers and Heidi Ames. This is a landlord-tenant case brought under the Montana Residential Landlord and Tenant Act, as well as the Security Deposit Act, and as well as the Montana Consumer Protection and Unfair Trade Practices Act. Professor Juris did a very good summary of this case. I won't go over it again. I have given to the court a handout which has highlighted portions of the lease agreement, the collection agreement, and a case that I wish to refer to that was not briefed before the court. The form of the lease agreement in this case is important. It is a pre-printed form. On the lease and the associated documents that were executed, the documents consist of pre-printed materials, an assortment of boxes or lines to check off regarding various elements of the lease, such as whether insurance is required, pets are allowed, and so forth. The body of the lease is in a smaller type with no check boxes. On page 10 of the lease, Crestview, the defendant in this matter, does incorporate highlighted text indicated by boxes. And to these boxes, the tenants are asked to place their initials. Portions of the lease, such as the mold disclosure statement and the pet addendum, are included as separate notices requiring separate signatures. Security deposit was required, $2,170. Rent was $935 per month. During the term of the lease, Matthew and Heidi had a death in the family and inherited some pets. It wasn't going to work in this third-story apartment unit to have additional pets, so they chose to terminate to find a house to live in that was appropriate. They gave notice. Crestview responded that they'd given proper notice to move out. Did a security damage deduction for cleaning and damages. I think it was approximately $160, and indicated that they would accelerate the balance of the lease.
Counsel, let me ask you a question initially. Is this agreement that you presented here, is that unique to Crestview, or is this prepared by some trade organization, or is this the form of lease used throughout the community of Missoula?
Your Honor, I can only speak to my experience. I have not seen this particular lease used by landlords in general. My belief is that it is unique to Crestview.
Thank you.
Crestview demanded, after the termination, after Matthew and Heidi moved out, the full sum of the remaining lease amount that would have been due through the end of June 2007. This termination occurred in 2006. Notice was sent to Matthew and Heidi on November 15th that the balance due was $6,505. The very next day, under the terms of the lease, this amount was assigned to collection, and a notice was issued demanding $9,758. This reflected the statement in the lease agreement that a 50% collection fee would be added to all amounts that were due under the lease agreement. This begins our analysis of the case. The Crestview lease is a literal archetype of prohibited provisions and the use of contracts of adhesion to mislead tenants as to their rights, and to extract from tenants illegal impositions of costs, illegal withholding of security deposits, and illegal representations that purport to convince the tenant that if the tenant exercises any of his rights to go to court, that the tenant will be liable for the landlord's attorney's fees. And this is the purpose of the highlights in the lease agreement, because there's several of these provisions in the very small type in the pre-printed portion of the lease agreement.
Counsel,
Yes.
you've indicated in your argument and in your briefs that there are some prohibited provisions contained in this lease. I'm looking at the Landlord-Tenant Act and specifically 70-24-202, which sets forth those provisions that are prohibited in rental agreements.
Yes.
I don't see from the listing there that any of the provisions that are at issue here are actually prohibited under the law. Could you address that, please?
Certainly, Justice Cotter. The very last provision of the Landlord-Tenant Act relates to attorney's fees, and it indicates that they shall be discretionary with a court. This lease agreement requires attorney's fees to be paid by the tenant if there is a court proceeding. And while this doesn't fall under the strictly prohibited, the statute you refer to, it is, I think, a prohibited action to require the tenant to pay attorney's fees no matter what, because there is a statute that says that it's discretionary.
Well, isn't there also a statute that provides that if there's such a provision in a contract and the other side prevails, that the other side is entitled to attorney's fees?
Yes, the reciprocal provision, attorney fee statute. That relates to our arguments regarding consumer protection and the fact that tenants and consumers don't know about that statute.
And it's your contention, whether it's, even though it's maybe discretionary, that, I'm sorry, that even though it may be reciprocal, that the contract doesn't point out that it's discretionary.
The contract actively misrepresents that in saying that it's not discretionary, that the tenant will pay those fees. Yes, Your Honor. On page 9 of the lease, under the highlighted paragraph, collection costs, it also says that there will be a 50% collection fee added to any unpaid balance. The last sentence in that paragraph states that the authorized fee of 50% and the additional costs and charges listed above represent the actual costs incurred by Crestview Apartments to collect amounts owed under this agreement. Now, in this particular case, that happened to be an out-and-out lie. We had our trial exhibit, Exhibit J, and it's Exhibit B in your handout, was the collection fee agreement that Crestview had entered into with its collection agency. The collection fee agreement does, in fact, have a provision for a 50% collection fee under certain circumstances. Crestview, in this case, got what was called the preferred or premium collection fee agreement, which by which certain amounts obtained a 25% collection fee. That was a big difference. Obviously, the tenants didn't know about this. Crestview misrepresented their collection fee agreement to the tenants. On the back page, the second page of that collection fee agreement, it also says something else that is very germane to what Justice Cotter asked about. It indicates that the collection agency assumes all the risk for attorney's fees. Essentially, Crestview has assigned its risk, its attorney's fees, to the collection agency under the 50% or the 25% collection fee agreement. If Matthew and Heidi responded to the notice that they got that you owed $6,000, now we've assigned it to collection, now you owe $9,700, $800, and they paid it, they would be paying the attorney's fees for which Crestview had assigned the risk to the collection agency. We think that's in violation of the statute. Reviewing the lease, we also see under the first entry on page 9, security deposit, that the landlord may deduct the amount necessary to compensate for all tangible loss, including, but not limited to, legal fees and collection costs. Farther down that page, the tenant agrees to confess, in essence, confess judgment for the full amount due, with a provision that a partial satisfaction will be filed if the apartment is later rented earlier than the expiration of the lease term. At the last paragraph, the tenant agrees again to pay all collection costs and all costs and expenses, including attorney's fees. And on page 10, at the last paragraph, under the section Termination of Tenancy, tenants are advised that costs related to collection are at the expense of the tenant. On page 11, under attorney's fees, the tenants are advised that all legal fees and collection costs incurred by the landlord due to tenant's failure to remedy a breach shall be the responsibility of the tenant. 5 distinct references are made in the body of this lease agreement which represent to the tenant unequivocally that the tenant will be responsible for collection fees and attorney costs, and that these may be withheld from the security deposit. On page 9 of that lease, there's also language that the entire principal rent amount due for the full lease term shall at once become due and payable at the option of the landlord, and judgment may be had for the amounts due. In the event that the rental premises are re-rented to another for the full value prior to the expiration of the lease term, the landlord shall file a notice of partial satisfaction.
Counsel, does your claim rise or fall on whether the lease contract constitutes a contract of adhesion?
Yes.
And what is your view with regard to whether any of the alleged illegal provisions are severable?
Your Honor, I was planning to discuss that later, but the case that is, I think, an important case, it's Barrell versus McTaggart. It's a Wisconsin Supreme Court case. We don't have a similar case on it, so I'm referring to that one, and it's in the back of your handout. Indicates that there's, and I think it fits very nicely with the analysis that this court has used regarding arbitration cases and the reason for striking arbitration clauses from consumer contracts. And that is, anytime the tenant gives up an important right or is convinced to give up an important right, that should be a prohibited clause, because tenants by their nature, consumers by their nature, don't understand all of their rights under our Constitution and under our statutes.
Now, in our arbitration cases, we've said that when a consumer is required to give up a constitutional right, access to courts,
Yes.
they have to be explicitly notified of that. Here we're talking about a consumer contracting away statutory rights. Do you think the same analysis applies?
I do, and this is why. Here, in the arbitration cases, there's the right to a jury trial, the right to a trial, the right to go to court. In this lease agreement, it's basically it isn't represented that you can't go to court. It's represented that you're going to pay all the costs if you're a tenant and all the attorney's fees if you go to court. The consumer cases that analyze the effect of that on tenants use the phrase, a chilling effect on their rights. And I think that's at least somewhat analogous to the rationale that's used in the arbitration cases.
Did your clients attempt to negotiate any of these terms at or before the time they entered into this lease?
The trial record in this